one criminal appeal, my lord, your lordship is order for listing the matter. After 1 week, my lord, it does not come. Let it come on, my lord, on 13th Tuesday. Man is in jail, my lord.
Criminal appeal of which year? For hearing?
Hearing,
For hearing?
hearing, because you listed in the
Then you make an application before the registry.
Hmm.
Because all these hearing matters are from the hearing list. We have a hearing list.
Yes, this was also hearing, my lord, but on that day it couldn't be
No,
completed.
we have a hearing list.
Yes.
All these hearing matters are incorporated in the daily list
Yes.
from the hearing list only.
Yes. But
That is the convention as followed, as observed by the Honorable Chief Justice. So, what is the period of detention?
my lord, case is of 2005.
Period of detention?
Detention is now 1 year something. About
1 year.
1 year,
We
7
have
months.
7 years, 8 years.
Old man, my lord. 67.
All are men. The case we are going to take up is, I think, 70 years. Mr. Anjay Das. He did not.
It has a lordship's order.
He has 5 years detention,
Your
7 years detention. How many?
lordship's order, my lord, that let it come next week, after 1 week.
Hmm?
The lordship's order.
Make an application before the rest. Not out of turn hearing.
May it please, Sir Lordship. Lordship, I beg to mention item number 10. Mr. R. Sharma has been appointed as the amicus curiae in this matter. Lordship is out of station today.
Okay. MS?
M. Kakoti.
M. Kakoti. Learned counsel appearing for Mr. R. Sharma, learned amicus curiae for the appellant has submitted that Mr. R. Sharma is out of station on personal ground. So, and has thus submitted that, has thus prayed that matter be listed after 2 weeks. MS A. Begum, learned additional public prosecutor for a respondent state is present. In view of the ground cited for adjournment, command of the prayer is allowed, list the appeal after 2 weeks on a date to be fixed by the office.
Obliged, sir.
Part heard matter, item number 12.
May it be resolved. Which I have gone through, my lord, the evidence on record, my lord. Possibly in my humble understanding, my lord, whether, my lord, the sentence awarded can be converted or if reduced into, my lord, possibly.
Let us see.
My lord. My lord, FIR was lost by, my lord, Mamoni Nath, my lord, wife of the deceased, my lord. That lordship will find the FIR at page 4, my lord. Married, my lord. Married. With due respect, I beg to submit that around 1:30 p.m. yesterday, that is on 10/7/12, my husband Kitishnath was returning from Bornibari market on the way, he took some rest at Kokoya Nirola Chowk by sitting on a bahar chang, a raised platform made of bamboo, and thereafter as he got on his bike to return home, Sri Nilokanto Nath, the eldest son of late so-and-so, of village Kokoya under Dharampur Moja, armed with an iron knife, arrived there all of a sudden, and coming from behind, he stabbed my husband on his belly, thereby causing grievous injury to him. Then Sri Kalicharan Nath, Pulendas and Jitendas took my husband to Nalbari Civil Hospital in a small car in an unconscious state, but he was not admitted into Nalbari Hospital. And at the time when the doctor took the decision to refer him to Guwahati Medical College, he breathed his last there. There are witnesses who witnessed the incident and they will substantiate it. Now, my lord, as per the FIR, my lord, this Kalicharan Nath, Pulen and Jitendas were alleged to have been present, my lord, at the time of occurrence. Now, PW1 is the informant, my lord. Possibly she is hearsay witness, my lord. Number 2 is the one eyewitness, my lord, Kalicharan Nath, my lord. I will read it PW2, my lord.
Hmm.
I know the informant and her deceased husband Kitish Nath. I know the accused Nilokanto Nath. Incident took place in the year 2012. I own cycle repairing shop at Nirola Chowk. Accused Nilokanto Nath owned a tea stall in front of my cycle repairing shop. On the date of incident, deceased was sitting on the bamboo bench present in front of shop of Dhanjit and talking with one Jiten Das. When Kitish was about to go home on his TVS bike, accused Nilokanto Nath came with a knife and stabbed him in between just below the chest and just above abdomen in the left side. Immediately Kitish fell down and I, Jiten and Pulen stopped the auto car of Tahinur, which was driven by his son, is coming there and took Kitish to Kokoya Hospital. In the said auto car, doctor at Kokoya Hospital, after examining Kitish, referred to SMK Civil Hospital, and we took Kitish to SMK Civil Hospital in the said auto car. Doctor of SMK Civil Hospital advised us to take the injured Kitish to GMCH. We arranged money and one Maruti van to take Kitish to GMCH as asked by doctor. But by the time we were able to arrange the vehicle, doctor of SMK Civil Hospital declared him dead. After inquest, postmortem was conducted on the dead body of deceased. Thereafter, dead body was handed over to us and his last rites were performed. On the next day, wife of deceased lodged the Ejahar. Police recorded my statement. Now, cross-examination, my lord. Deceased was my cousin brother. The bench where deceased sat prior to incident is owned by Dhanjit, owner of Pan Shop. Total 4 shops are present at Nirola Chowk. One is my cycle shop, another is Dhanjit Pan Shop, tea stall of accused and grocery shop of Moloya. Now these shop owned by Dhanjit and Moloya, my lord, those were possibly closed. And possibly that is why, my lord, they were not examined. Possibly Dhanjit examined, my lord. The incident took place at about 1:30 p.m. At the time of incident, myself and Jiten Das was present and other persons arrived immediately after the incident. Mother of Moloy Das, mother of Ajit Das, Pulen Das, Rotne Talukdar arrived in the place of occurrence immediately, did notably after the incident. Immediately after the incident.
Immediately after.
My accused said Pulori Papar at his tea stall. I, Kitish, used to take tea at accused tea stall. I sometimes take tea at accused tea stall on credit. By the time we arrange vehicle and money to take Kitish to Guwahati, doctor declared him dead. So we could not take him to GMCH. It is not a fact that I did not make statement before police. The doctor of SMK Civil Hospital advised us to take the injured Kitish to GMCH. We arranged money and one Maruti van to take Kitish to GMCH as asked by doctor. But by the time we able to arrange the vehicle, doctor of SMK Civil Hospital declared him dead. It is not a fact that Kitish went to accused tea stall and asked accused to give him tea, Pulori Papar on credit, which accused refused to give him, for which Kitish punished him and pulled down him on ground and sit on the body of the accused, and at that time accidentally the knife in the head of accused pierced into the body of Kitish. This is the defense, my lord.
This is a defense. Where is that accept suggestion?
Well, accept suggestion, possibly lots of will kindly bear with me, my lord. Here the deceased was 35 years of age. And my lord, with all respect, the accused at that point of time, in the year 2012, possibly he was 62. 62, my lord.
Where is the foundation to bring in?
My lord, that is.
You have to culpable homicide
My lord,
and culpable homicide amounting to murder or not amounting to murder.
my lord,
How you bring in the exception?
my lord. Possibly in the evidence of PW4, my lord.
Let us see, but
Fine.
this is only a suggestion,
This is a suggestion. Okay? This is a
nothing more
suggestion.
than that.
Nothing more. It could not substantiate later on.
Let us see
My lord,
whether you have substantiated.
that altercation part, Lordship will
Hmm?
find it. That altercation part
Ah.
prior to the incident, my lord, Lordship will kindly find it in the evidence of PW4, my lord.
Okay, let us read.
My lord. Now PW3, my lord. I know informant Mamoni Nath. I know the accused Nilokanta Nath present before the court. I know the deceased Kitish Nath as all of them hail from my village. My tailor shop is present at Bornibari Chowk and I came to my shop at 8 a.m. On the day of incident, Bornibari Chowk, I heard about taking place of fighting incident at Nirola Chowk while coming to Nirola Chowk from my tailor shop. On reaching Nirola Chowk, I again heard that fighting incident took place between deceased and accused inflicted stab injury on Kitish Nath and he was taken to Kokoya Medical and then shifted to Nalbari Civil Hospital. In the evening, I heard that Kitish succumbed to his injury at the hospital. So far as this evidence is concerned, my lord, possibly there were two incidents only in my humble
It
understanding.
should go against the law.
My lord,
Here's the evidence.
my lord, my lord, my lord. Now,
We
possibly,
will be swimming against the settled law
my lord,
if we go to believe this.
my lord, my lord. Now, my lord, may I read PW4, my lord? I know the informant Mamoni Nath accused Nilokanta Nath present before the court and it is the deceased Kitish Nath as all of them hail from my village. About 7 years back, accused Nilokanta Nath inflicted stab injury by a knife on Kitish Nath just above abdomen and just below chest. On the day of incident, just before incident, Kitish Nath and I was sitting on a bench present near the shop of Kalicharan. At that time, when Kitish Nath just wanted to go home and took seat on his motorcycle, accused Nilokanta Nath came and inflict him stab injury with a knife in my presence, and Kitish Nath shouted Nilokanta gave him stabbed injury by a knife. Myself and Kalicharan took Kitish Nath to Kokoya Hospital, and doctor of Kokoya Hospital referred him to SMK Civil Hospital, and SMK Civil Hospital referred it is to GMCH after stitching the injury, and after 10 minutes, Kitish succumbed to his injury. Thereafter, the dead body of Kitish brought to home after postmortem. Now, let's cross-examination. Deceased Kitish was my co-villager, and from my Suburi, myself and Kitish was sitting on the bench, and Kalisharan was present near us at that time. The cycle repairing shop of Kalisharan is present near the place of occurrence where myself and Kitish are sitting. I did not pay attention about the presence of other person at Nirola Chowk at the time of incident. Apart from me, Kitish, accused and Kalicharan. The pistol of accused Nilokanta is about 30 feet distance from the bamboo bench. I did not see this is Keating taking tea at the tea stall of accused. I never take tea at accused tea stall. It is not disclosed that accused Nilokanta inflict him stab injury by a knife. At the time of incident, I was sitting on the bench with head down about 15 feet distance from Kitish and accused where they were altercating. And before the stabbing incident, there was an altercation between the accused and Kitish. Well, possibly because of this reason that suggestion was put. There was four shop houses present at Nirola Chowk at the time of incident, and at the time of incident, shop of accused Kalicharan are opened and other two are closed. I was sitting on the bench prior to arrival of Kitish. I do not know where from Kitish came at that time. Now I cannot remember whether I make statement before the police that when Kitish was about to go home and sit on his bike, accused Nilokanta inflict him stab injury with a knife. Myself, Kulendas and Kalicharan took injured Kitish to the hospital in a car which was stopped by villagers that was coming to our village. but not in 108 ambulance. After the incident, several villagers came to the place of occurrence. I did not count the number of villagers arrived in the place of occurrence. I cannot say the name of people who gathered at the place of occurrence as I was busy with the injured and I did not look at the face of the persons who were come to the place of occurrence after the incident. It is not a fact that Kitties has to pay credit amount of Nilokanto's tea stall and therefore I deposed falsely before the court. I have seen the knife in the hand of accused Nilokanto. I separate Nilokanto from the deceased and at that time I noticed the knife in his hand. Thereafter, what happened to the knife is not known to me. I do not know what gathered people do with accused Nilokanto. It is not a fact that as deceased Kitties Nath is closely known to me, I deposed falsely before the court. Now 5 is the doctor, my lord. According to him, my lord, injury sustained and size of the injury is 3 into 1 cm. And there was no exit wound, my lord. But, my lord, his liver was ruptured. Spleen also ruptured, my lord. I will read, my lord.
No cross.
No cross, my lord. Why one line crossed by defense, my lord?
Nothing material.
Nothing more, nothing more. Now, my lord, PW6, my lord.
Hmm.
I know this is Kitties Nath and his wife Mamoni Nath, the informant of the case and the accused Nilokanto Nath, as all of them hails from my village. About 7 years back, incident took place at the place of occurrence. Kitties, accused Kalicharan and Jiten were present. I was coming to the place of occurrence from a little distance and at that time I heard that accused Nilokanto stepped Kitties and there was hue and cry. I noticed injured Kitties, who is the deceased of this case, with his injury on his abdomen and profuse bleeding from injury and blood did not stop. And injured Kitties was immediately taken to Kokoya Hospital in a Maruti car, which was stopped by us. The said Maruti car was coming to the direction of the place of occurrence. We stopped and taken injured to hospital first at Kokoya and thereafter to SMK Civil Hospital, Nalbari. I accompanied injured to the hospital and after 10 minutes of injured arrival at SMK Civil Hospital, injured Kitties succumbed to his injury. Thereafter, post-mortem was done on the dead body and thereafter his dead body was taken to home and his last rites were performed. Cross, my lord. I did not witness the incident of stabbing injured by the accused, but I heard the incident from Kalicharan and Jiten. When came to the place of occurrence, deceased was not my relative and he was my co-villager. Incident took place at Nirola Chowk and accused owned one tea stall at Nirola Chowk. Police did not record my statement as police did not ask me. So I did not make statement before police that I took injured to Kokoya Hospital in a Maruti car and then.
But he is listed witness in the search sheet.
My lord. True, my lord. And IO has also said he recorded his statement. Why he, my lord, it is there, my lord. Now 7, my lord.
So far, after the incident,
My lord.
this man arrived
My lord.
and this man has been named by both
2 and 4, my
2
lord.
and 4.
My lord. My lord. 2
So
and
his
4.
arrival
My lord.
at the place of occurrence
My-
immediately after the stabbing
My lord.
is supported by PW2
2
and
and 4.
PW4.
My lord.
And he was a witness. He was a witness who took the injured along with PW2 and PW4 to the hospital.
Hospital, my lord. True, my lord. 7 is my lord. Is hearsay, my lord. 8 also, my lord. Hearsay. Now 9 is son of the deceased, my lord.
Hmm.
9. May I read, my lord? Informant Mamoni Nath is my mother and this is Kitties Nath is my father. I know accused Nilokanto present before the court. The incident took place about 8 years back during daytime. On the date of incident, while I was present at my house, Manos Protim Hazarika, came to our house and informed that my father was stabbed by accused Nilokanto at Nirola Chowk and he was taken to SMK Civil Hospital, Nalbari by Kalicharan Nath, Jiten Das and Kulen Das in a Maruti car. My father was first taken to Kokoya Hospital and from Kokoya he was referred to SMK Civil Hospital, Nalbari. Hereafter I came to SMK Civil Hospital, Nalbari and got the news of death of my father. Police was already informed about the incident by some other person and police arrived at hospital. Inquest on the dead body was done at SMK Civil Hospital in my presence and thereafter autopsy on the dead body was done. And after autopsy, dead body was handed over to us to perform last rites. Exhibit 3 is the inquest and 3-1 is my signature. My lord, cross part, my lord. I am HS Pass. Place of occurrence is 1 kilometer away from my house and I was sleeping at my house at the time of incident. Now I forgot the time when I reached Nirola Chowk. I noticed youths gathering at the place of occurrence, but I did not pay attention. Who are they? As I got the news of death of my father, Nirola Chowk is a small shop and at the relevant time of incident, there were 3 shops present which I know and the shops belong to accused Nilokanto Nath, Moni Das and Poromesh Nath. Now, my lord, interestingly, the shop of him is the shop of Kalicharan, my lord. But, my lord, in the sketch map, it is the shop of Kalicharan is shown, my lord.
Hmm?
In the
Oh.
sketch map, my lord.
Kalishan himself says he has a
My
shop.
lord. But he missed.
Huh? Is
My lord. He says, he says, my lord.
B is
My lord, shop of Kalicharan.
B. Then road. A is road. Place of occurrence. C. Nilonath. Nilonath is the accused.
My lord.
Nilonath.
Nilokanto, my lord.
Hmm. I think Kalisharan is the best person to say who
Why
has
not?
shops there.
My lord. But this witness missed out, my lord.
Hmm.
My lord, belong to accused Nilokanto Nath, Moni Das and Poromesh Nath. Shop of accused Nilokanto is a tea stall. To my knowledge, my deceased father do not take cup of tea at Nilokanto's tea stall while going to his work. And at the time of return from work, it is not a fact that my father had to pay credit amount to accused Nilokanto. House of Manos Pratim Hazarika is present near the Nirola Chowk. It is not a fact that I depose falsely that my deceased father do not take up tea at Nilokanto's tea stall and while going to his work and at that time of return and at the time of return from work. It is not a fact that on the day of incident my father wanted to take tea from tea stall of Nilokanto on credit, which Nilokanto refused to offer him, and then scuffle took place between Nilokanto and my father. And at that time, the knife present at the hand of Nilokanto accidentally pierced in my father's body.
So what else then other than suggestion?
My lord, there is nothing. Now, IO is PW10, my lord.
Hmm.
On 10/7/12, I was working as attached officer at Belsor PS, and on that day, OC Belsor PS received one written ejahat from Mamoni Nath, and he registered Belsor PS case number so and so under section so and so, and endorsed me with the charge of investigation. Exhibit 1 ejahat, 1-2 is the signature of the then OC so and so. Taking the charge of investigation, I visited the place of occurrence, which is the Nirola Chowk of village Kokoya, and found accused Nilokanto Nath committed murder of Kitish Nath by stabbing with a knife. I have recorded statement of witnesses and prepared sketch map of the place of occurrence. Accused surrendered at Belchor PS. He was arrested and proceeded before learned magistrate. I have seen the dead body of at SMK Civil Hospital, Nalbari, where postmortem was conducted. Thereafter, inquest on the dead body was done by an executive magistrate. I have collected postmortem report on the deceased, and after completion of investigation, submitted charge sheet against the accused under section 302. Exhibit 4 is the sketch map of the place of occurrence. 5 is the charge sheet. Exhibit 4(1) and 5(1) are my signatures. Across my law, nothing of that sort. I have not seized any material in connection with this case. Dead body was sent to FSL. I have seen the dead body of Kitisnath at SMK Civil Hospital at 4:30 PM on 10/7/12. I did not record statement of scribe of the Ejahar. I did not record statement of Gaura of deceased village. I did not record statement of Manospati Majorika, Rotne Talukdar, Moni Das, and Poroma Das. I had recorded statement of witness Kulon Das. Witness Kalicharan Nath did not make statement before me. The doctor of SMK Civil Hospital gave advice to shift deceased. It is not to GMCH. It is not a fact that I did not visit the place of occurrence. It is not a fact that the investigation is not properly done by me. It is not a fact that I have submitted charge sheet against the accused under influence of Mamuni Nath, wife of deceased Kitisnath. So it is the overall evidence, my lord.
There is nothing in 313 then,
My lord.
that there is a couple.
But that is, well, it varies, his suggestion and his
It got,
plea taken in 330.
when he says
My lord,
in 313,
But-
he said something else.
my lord,
Question number, he admitted
my lord,
his presence.
my,
See question number 4,
my lord, he admitted.
question number 5,
My lord, my lord,
question number 8,
my lord,
then question number 9.
my lord.
See what is the story?
My lord,
He said, used to give them mixer, they hold me. They hold me and I have sustained injury in my
my lord,
head and shoulder. And if it turns out to be false plea,
my lord.
you should have
He should have,
brought something.
my lord. He could have possibly examined himself as a defense witness.
Here, in the explanation, there is nothing regarding credit.
My lord,
Nothing regarding credit.
my lord,
Then, yes, he was refused to give him, for which it is pushes him. Refused to give them mixture. Tea Fulori Papor. Tea Fulori Papor.
my lord,
Tea Fulori Papor on credit. Preparing and again mixer. I refuse to give them mixture. They hold me. Sustain injury.
my lord. He being a felon-
Had you laid any evidence regarding your injury?
no, 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 no.
What?
No, my lord,
You were absconding initially
My
for 10 days.
my lord,
Kesari says, though he says that surrendered,
my lord.
but Kesari says
He was arrested.
you were hiding somewhere.
No.
From not in your own house, somewhere else. Even orders it reflects that.
My lord.
So how
Only thing.
how from 299 to 300 to exception?
Because of
302 exception.
PW4, my lord, my humble submission.
How?
My lord, this part, my lord, cross
Which part? Tell me which exception?
My lord, 4, my lord.
What? What are the requirement?
My lord, it should be sudden.
Huh?
There has to be sudden fight,
Hmm.
my lord. And my lord, there was no undue advantage taken, my lord.
Hmm.
Without premeditation and without taking.
Where is your injury?
My lord, injury is one, my lord, with all respect, my lord.
I pieces.
Injury is one, my lord. My lord, possibly, my lord, he had the knowledge that, my lord, the injury he attributed would possibly lead to cause, my lord, death. But considering that one single injury, my lord, that he possibly did not have the intention to cause death, my lord. That is my understanding. Four, my lord, exception, culpable homicide is not murder if it is committed without premeditation. There is an altercation, my lord, it is in evidence. In a sudden fight, in the heat of passion, upon a sudden quarrel, without the offenders having taken undue advantage or acted in a cruel or unusual manner.
If they ask Pokori and all
My lord,
in your shop,
my lord, my lord,
and why you travel a distance to the bench and stabbed him?
my lord.
Eyewitness account is more trustworthy.
That is true, my lord.
Now, you travel a distance from your shop
My lord,
to the bench, bamboo bench,
My
and
lord.
stabbed him.
my lord. But lordship sketch may show, my lord. Sketch may would show, my lord, that the incident took place on the road, my lord. And my lord, the distance between the two my lord, it is not far away, my lord. Possibly when, my lord, after the altercation, he tried to, it is in the evidence that when he tried to get up on his bike, my lord, the accused came and gave the, my lord, assault, gave the blow. It is in the evidence of PW2, my lord. Eyewitnesses possibly, my lord, their presence cannot be denied. But regarding that altercation part of it, my lord, PW2 is totally silent. Totally silent, then there happened some altercation. And it is in the cross part of PW4, my lord, that it has come out. So he in chief examination, my lord, he is also totally silent regarding the altercation. My lord, trying to, my lord, possibly hide the true genesis, my lord, in my respectful submission, my lord.
No, they are not inimically
No,
disposed
I
towards you.
understand, man. I understand.
They have not brought anything
No,
that
no,
they
no.
are,
I understand, man. But only thing is that
they are in the category of independent
Mine.
witness. Though Kalisaran was a cousin or
mine,
something,
true,
but
But-
there is nothing adverse against them.
my lord. Only thing is that, my lord, they failed to, my lord, narrate before the court what led to the incident, my lord. What led to, my lord, the accused taped the deceased, my lord. That is my humble submission. Because my lord, as I have submitted, my lord, appellant is possibly at that point of time 62. And there is no evidence that earlier they had some enmity regarding land or anything, my lord. So something might have taken place in between, which is apparent from the evidence of PW4 that he lost his self-control, my lord, and my lord gave the steam. With the knowledge, with well respect, my lord,
Your defense plea is different.
my lord. My defense is that, my lord, when he tried to, he,
That Kitties pulled him, pushed him, pulled down
my lord,
him on the ground, sit on the body of the accused.
my lord,
At that time, accidentally, the knife in the hand of the
My-
accused pierced into the body of the
My-
Kitties.
my lord, as it is not substantiated, my lord, as I have pointed out, 62 years and 35 years, my lord. That possibility in my respectful submission,
We cannot imagine
my lord,
things.
I true. That
We
is
cannot
true.
imagine
That
things.
That is true. That is true.
Cannot imagine things.
My
We
lord,
have
that is
to
true.
go by the papers.
My lord, that is true.
What has come out?
My lord, true. Only thing, my lord, that evidence of PW4, my lord.
Okay, so here is exceptional report. কিবাটো ক'ব লাগিব ন কিবা এটা যে ই কিবা এটা কৰিছে ডিজিজ যে কোনো একো হেৰিটো নাই দত্ত নাই নেকি চাওঁ এইটো এই ওপৰৰ এইটো নহয় এইটো উৰাব নালাগে ৰ'ব এইটো নহয় তাৰ তলৰটো চাওঁ তাৰ তলৰটো তাৰ তলৰটো তাৰ তলৰ তাৰ নহয় তাৰ ওপৰৰ এইটো নহয় তলৰটো Yes, Mr. Rao.
Okay, so firstly, I want to state here that
Hmm?
accused is present there. It is not denied, Lordship. Moreover, he is also armed with knife. Moreover,
He is a tea stall owner.
Lordship,
He is a tea stall owner.
Lordship.
Accessibility to a knife.
The eyewitness is also there, Lordship, 2 and 4.
Hmm.
Again, 4 is also present there, Lordship. 2 is also present there. He is also happened to be an eyewitness, Lordship. He has not said anything about this altercation. This altercation, Lordship, has not stated. And moreover, PW1 is informed by one Deepak, Lordship, in front of whose shop the occurrence took place.
PW1 hearsay.
Lordship, here in this place, Lordship, he is informed by Deepak, Lordship.
Deepak was not
Yes.
examined.
Yes, res guest,
Deepak-
Lordship. Res guest, sir.
Raise this, but Deepak has to say that.
Lordship, Deepak.
Deepak has to say that to being raised this year, not PW1.
Lordship. And moreover,
What
Lordship,
is this here?
at the same transaction, Lordship,
Uh,
time is not matter here.
uh.
Duration is not matter, Lordship.
But
Time-
she was not in the picture
Lordship,
when the injured was taken to Kokoya,
Lordship,
then Nalbari,
Lordship.
right? She was not in the picture.
No, this person informed him that the whole incident.
Right,
Lordship,
at what time, where? It is to be in proximity of time
Lordship.
to bring as this here.
Lordship. Moreover, Lordship, the incident, how it occurred, Lordship, it corroborates with the medical evidence, Lordship. Above, below the chest and above abdomen.
Right, it is a case of culpable homicide. Now, if you go by the settled law,
Hmm.
it also, the case also is brought in within the purview of, can be brought in within the purview of section 300.
Hmm.
Now, his submission is that the case is one which can be brought
Under exception, Lordship.
within the exception 4.
But his defense is not
How
substantiated
how
confidence,
that
Lordship.
how it travels? Two exceptions. How? What is the manner of appreciating a case
Lordship.
to be within one of the exceptions?
Lordship, regarding this, he has attacked, Lordship. He has not put forward any evidence on that, Lordship. Regarding his.
But it has come out from, say, respondent number PW4. PW4,
But he is not substantiated by other evidences, Lordship.
not only two.
Lordship,
There were two witnesses.
Lordship.
Nobody said that there were more eyewitnesses. Nobody said. At rural area, in a chalk, having 4 shops, 2 shops were closed, 2 stall owners were there. One is Kalisharan, the other is Nilakantor.
Jiten,
And this man stopped.
Lordship.
And the other one, Ziten, was sitting.
Lordship.
Everybody came later on. This PW 2 and 4 said, everybody came later on. PW 5 also
Lordship.
reached immediately after the incident. He was not there. So only 2, PW 2, PW 4, the accused and the deceased. They were at the place of occurrence. It seems we don't find a presence of anybody at the time of occurrence.
At the time.
Immediately after the occurrence, yes, there were presence. So, in such situation, exception comes or it does not come. Hey,
But in the cross of
more
PW
than
four,
them are Heroes heroes, heroes এই যে আর্জারি আছে রেডিও ফিরোজ সামনে তিনটা সব প্রথম গেলে একটু আগেও কিন্তু তোমার প্ৰথম আহিব ভিসা চিংগি আহিব লাগিব পুনা ভেলু আহি পেলাই তাৰপিছত এক্সেপশ্যন থাকিব
There are 2 judgments, my lord. I will place, my lord.
Which
But
one?
I could not, my lord, obtain the piece, my lord, because
You should have come prepared.
my lord, I am sorry, my lord. I have asked them to come, my lord.
Not required.
My lord.
Since you have not come with that preparation, we'll use our resources.
My lord. My lord, the man in the library, he did not arrive, my lord.
You had the whole night yesterday.
My lord, whole night stuck up in the, my lord, flood night.
As because it is jail episode.
My lord. No, 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 my lord. No, my lord.
We have seen from our experience that is
No,
why.
ma'am. I waited 15 minutes, my lord, when the boy Dinesh did not arrive, my lord. That's why I immediately come, my lord.
এই একদম তলৰটো চাওঁ তলৰটো নে থাৰ্ডলি ওপৰত থাৰ্ডলি বুলি লিখা চাওঁ গোটেইখিনি আনক বিৰচা সিং আছে নেকি বিৰচা সিং লছ থাৰ্ডলি লছ ফৰ্থলি এইটো থাকক সেইকেইটা চাওঁ single blow related.
My lord, I have got it, my lord.
Not required.
My lord.
Matok. This is 1956. Vivian Bosch. Visa Singh there. Then Visa Singh is 19. Vivian was 1950. 58 Supreme Court 465. Then Ulicherla Nagaraju. There is another one. Raya Bharapu Punaya. Hey, what's happening? Raya Bharapu Punaya. Yes. Section 1, প্রথম তো হবো thirdly. Section 300 thirdly. And it is murder. Murder, I will get exception from your father. Then it is again, it will come back to again. One is Raya Bharapu. Into okay. Oh, it to tell Seniki. Oh, right. Okay, take your seats.
Right.
Treat করে তাৰপিছত চাবলৈ এইটো exception কৰে। এইটো question হ'ব পাৰে। So then alteration হয়। Single flow, not more flow. Double হলেই আনিব নোৱাৰি। আৰু heat of patient. Sudden right. Sudden quarrel. Purification running down, people have bullshit. People are good by us. He is in his stall himself. So thermal purification, then we quarrel to place. Whatever was in his hand, he said with some point. The injury was such that so it is a matter. The matter of what can do to exception was exception 4 mean 304 the present female appeal. From jail is preferred under section 383 Code of Criminal Procedure. Against the judgment and order dated 2/8/2021 passed by the Court of Learned Sessions Judge Nalbari in Sessions case number 61 of 2015. Full stop. After the trial, the learned trial court the learned trial court finding the accused appellant guilty of the offense of murder under section 300, Indian Penal Code, had sentenced him under section 302, IPC. To undergo rigorous imprisonment for life and to pay a fine of rupees 50,000, in default of payment of fine, to undergo simple imprisonment for another year. Full stop. The learned trial court had further observed that the period under detention would be set off under section 438 CRPC, and the fine, if paid, has has his courier. And the fine amount if paid, comma, the same should be paid to the wife, comma, children, and parents, comma, if any, of the deceased equally. Full stop. Para. It was Asian case now, which arose out of Belsor Police Station, case number 81/2012. Para. The investigation into the case, comma, Belsor Police Station, case number 81/2012 was had commenced on a receipt of a first information report from one Mamuni Nat as the informant. By the officer in charge, Belsor Police Station, at about 7 p.m. on 10/7/2012. Also, as per the FIR, comma, in the FIR, comma, the informant had inter alia stated that at around 11/7, 11/7. 11/7, huh? Had inter alia stated that at around 1:30 p.m. on 10/7/2012, within bracket, Tuesday, comma, her husband, comma, Khitish Nast, while returning from Bornibari market, had made a halt at Kokoya Nirola shop. So the informant had alleged that while her husband, comma, Khitish Nast, was sitting on a bahar sang, within bracket, a raised platform made of bamboo, after having some rest on a bahar sang, when he got on his bike to return home, commander accused VIJ Nilakanta Nath, who hailed from the same village, comma, came near him armed with an iron knife and stabbed her husband all on a sudden on his belly. Full stop. As a result, comma, her husband, comma, Khitish Nath, sustained grievous injury on his person. Full stop. Then three persons, Das Kalisharan Nath, Kulen Das, and Ziten Nath, took her husband to Nalbari Civil Hospital in a small car. But he breathed his last before. The injured breathed his last before. Her husband breathed his last before he was taken to the Guwahati Medical College and Hospital, as per the advice of the doctors at Nalbari Civil Hospital. Full stop. Para. On receipt of the FIR, the officer in charge, Belsore Police Station, registered the same as Belsore Police Station, case number 81/2012, under section 302, IPC. Full stop. The investigation of the case was entrusted to one Narayan Kolita, a sub-inspector of police attached to Belsore Police Station by the officer in charge, Belsore Police Station. First, Narayan Kolita, PW 10. On being entrusted with the investigation, Narayan Kolita Rayo visited the place of occurrence, PO, that is, Nirola Chowk at village Kokoya, and prepared a sketch map of the PO EXT 4. Full stop. As the injured was taken to SMK Civil Hospital, Nalbari. Prior to his death, Dayo visited SMK Civil Hospital, Nalbari, to take stock of the situation. And going there, he found that the injured succumbed to the injury there. Full stop. Accordingly, inquest on the dead body of the deceased was conducted. At Shohid Mukunda Gangoti Civil Hospital on 10/7/2012 by one Bhaskar Das, Executive Magistrate and Circle Officer, Nalbari Revenue Circle, and after the inquest proceeding, an inquest report EXT3 was prepared recording the findings therein, full stop. The dead body was thereafter, the postmortem examination, the dead body of the deceased, Kitty's nut was performed at SMK Civil Hospital on 10/7/2012. And after the postmortem examination, the findings were recorded in a postmortem examination PME report EXT2. Full stop. The IO also recorded statements of a number of witnesses under section 161 CRPC. Full stop. After completing investigation into the case, Elsa police station case number so and so, within bracket corresponding GR case number 927/2012, the IO submitted a charge sheet under section 173 to CRPC, right, charge sheet number 88/2012 on 19/10/2012, finding a prima facie case well established. Prima facie case under section 302, IPC, well established against the accused. Full stop. During the course of during the course of investigation, the IO also arrested the accused after few days of the alleged occurrence. Conduct was enough. That conduct was enough. And produced the accused before the court on 2/7/2012. 27/2012. Post of para. After the accused was allowed to go on bail prior to submission of the charge sheet. Full stop. Absolutely. On submission of the charge sheet, the Court of Learned Chief Judicial Magistrate Nalbari secured the appearance of the accused before it on 2/5/2015. Full stop. On appearance of the accused, on such appearance of the accused, the copies of the case were furnished to the accused in compliance of the provisions contained in section 207, CRPC. Full stop. As the offense under section 302 IPC is exclusively triable by the Court of Session, the Court of Learned Chief Judicial Magistrate, Nalbari, by an order of commitment of dated 2/5/2015, committed the case records of ZR case number so and so to the Court of Sessions, Nalbari. Posto. The accused was allowed to remain on previous bail on an application being filed by him. Posto. Would have further direction to appear before the Court of Sessions on 27/5/2015. Posto. The learned public prosecutor was notified accordingly. Posto. Para. On receipt of the case records of ZR case number so and so pursuant to the order of commitment, the Court of Sessions registered the case as Sessions case number 61 of 2015. Posto. On appearance of the accused and upon the case was opened by the learned public prosecutor. Post after hearing the learned public prosecutor and the learned defense counsel and upon producer of the materials on record, the learned trial court, on, 25/11/2019, framed the following charge, page 7. When the charge was read over and explained to the accused, the accused pleaded not guilty and claimed to be tried. Post. During the course of the trial, the prosecution side examined 10 number of witnesses and exhibited 5 number of documents in order to bring home the charge against the accused. The prosecution witnesses examined were page 51 and the documents exhibited during the trial were page 51. After closure of prosecution evidence, the accused was examined under section 313 CRPC by to explain the circumstances which have appeared against him from the testimony of the prosecution witnesses. First up, the plea of the accused was of denial. First of, when the accused was asked as to whether he would adduce any evidence in support of his defense, the accused declined to adduce any such defense evidence. First of, after hearing the learned counsel for the parties and upon appreciation of the evidence of materials on record, the learned trial court by the judgment and order dated so and so has convicted, has delivered, has rendered the judgment and order of conviction and sentence against the accused, as mentioned here in above. First of, hence the instant appeal. First of, we have heard Mr. N.J. Das, learned amicus curiae for the accused appellant, and Mr. K.K. Das, learned additional public prosecutor for the respondents. I got on appearance there still, on appearance of the accused before the Hydrotra. A committed the case record before the session code on 27/5/2015 no? তাৰ পিছত এটা pair. Though the case was fixed on 27/5/2015 for appearance before the learned Sessions Judge Nalbari, that is the trial court. On to this way, the accused did not appear on that day, showing cause. First of, the accused remained absent on two subsequent occasions. No, on one subsequent occasion with steps, but thereafter, he remained absent without steps. As a result, the learned trial court had to issue non-bailable warrant of arrest to secure his appearance before it. Post up. When non-NBWA could not be executed, the learned trial court had to issue proclamation and attachment. Order, proclamation and attachment against the accused. Full stop. In the year 2019, the prosecution received an information that the accused, by changing his name from Nilkanta to Nilkamal, was staying at Kamakhya temple as a priest. First up, on receipt of such information, The learned trial court passed an order on 21/10/2019 to apprehend the accused and to produce him before the court along with a report on P&A stroke NBA. Full stop. Accordingly, the accused was arrested and produced before the trial court on 22/10/2019. On being so produced, the accused was remanded to judicial custody. Full stop. Where? Episode 25. After the trial from line to after securing appearance of the accused from jail custody on 25/11/2019, the case of the prosecution was opened by the learned public prosecutor. Yeah, Mr. Das learned amicus curiae appearing for the accused appellant has submitted that the conviction of the accused was made on the basis of eyewitness accounts of two prosecution, mainly based on two prosecution witnesses, PW2 and PW4. Full stop. He has contended that though the injury was on a vital part of the person of the deceased, the evidence on record go to indicate that there was a quarrel between the accused and the deceased prior to the assault at the place of occurrence, wherein the accused has a tea stall. Full stop. As the place of occurrence was a place where four shops are situated, including the tea stall of the accused and the deceased at the relevant point of time made a visit there, it is evident that there was no premeditation on the part of the accused, as the accused, as the presence of the accused at the PO was natural. It is his submission that I'm sorry, Mr. Das has submitted that from the evidence stroke materials on record, it does not emerge that the accused had taken any undue advantage of the situation. As the assault was and the assault was made in the heat of passion, the trial court had urged to convict the accused for the offense of murder. It is his contention that the accused could not have been convicted for the for culpable homicide of the first degree. Para. Mr. Das, learned additional public prosecutor appearing for the state, has submitted that the direct ocular testimony of the prosecution witnesses, more particularly, the two eyewitnesses, were credible and trustworthy, and the defense by cross-examining them could not shake the prosecution case in any manner to create a doubt. First up, the injury was on a vital part on the person of the deceased, and the injury was sufficient to cause death in the ordinary course of nature. Full stop. He has contended that the learned trial court has rightly reached the finding that the case is one which is covered under clause thirdly of section 300 IPC. And therefore, the judgment and order of conviction and sentence passed against the accused does not require any interference. Post Mr. Das has also highlighted the conduct of the accused by specifically pointing out that immediately after the occurrence, the accused was found absconding. And even after the order of commitment, the accused, by doing a vanishing act, because of the act of abscondence on the part of the accused, the trial got protracted for a period of 4 years from 2015 to 2019. We have duly considered the rival submissions of the learned counsel for the parties. We have also perused the evidence of materials on record, including the testimonies of the prosecution witnesses and documentary evidence available in the case records of Sessions case number so and so, in original. We have also taken out of the citations referred to by the learned counsel for the parties. Para. Other than the autopsy doctor, PW 5 and the IO, PW 10. The other 8 prosecution witnesses deposed on the No, the testimonies of the other 8 prosecution witnesses were on the incident. Full stop. PW1 is the informant and the wife of the deceased. And PW9 is the son of the deceased. But they were not eyewitnesses to the incident of assault, alleged assault, which occurred on 10/7/2012 at Nirola Sok, Kokoe. Full stop. Like PW1 and PW9, the prosecution witnesses. PW3, PW6, PW7, and PW8. In their testimonies, stated that they did not witness the incident of assault. Full stop. It was PW2 and PW4 who testified to the fact that it was in their presence, the incident had occurred. Post. Therefore, it is apt, at this stage, to refer to the testimonies of. It is apt to refer to at this stage. It is apt to refer to the testimonies of the prosecution witnesses, PW2 and PW2, the 4 at first. Full stop. Para. PW2, Kali Sharan Nath. Stated that he is a cycle mechanic by occupation. Full stop. In his evidence in chief, PW2 stated that he knew the informant and the deceased, Kirtisnath, and the accused. Full stop. PW2 stated that he owned a cycle repairing shop at Nirola Sok, and the accused owned a tea stall which was in front of his cycle repairing shop. Full stop. deposing on the incident, comma, PW2 stated that on the date of the incident, comma, the deceased was set on on a bahar sang, within bracket, a raised platform made of bamboo. Within bracket, bamboo bench, for short. In front of the shop of one Tonjit and talk to it Ziten Das. Within bracket, PW4. Full stop. When the disease, comma, Khitis Nat was about to leave the place on his motorcycle. The accused came near him with a knife and stabbed him on his person, comma, just below the chest and just above the abdomen on the left side. As a result, comma, Khitis Nath fell down at the spot. Then, comma, he, PW2, comma, Zitendas, PW4, and Kulendas, PW6. By stopping a four-wheeler vehicle which reached the place at the time, comma, took Khitis Nath to Kokoya Hospital in that vehicle. The doctor who attended Khitis Nath at Kokoya Hospital, comma, after examining him, referred him to SMK Civil Hospital, comma, Nalbari. Accordingly, comma, Khitis Nath was taken by them to SMK Civil Hospital in the same four-wheeler vehicle. At SMK Civil Hospital, comma, the doctors advised them to take the injured, comma, Khitis Nath to the Guwahati Medical College and Hospital. They then arranged money and another vehicle to take the injured, comma, Khitis Nath to the GMCH, comma, as if asked by the doctor, comma, but by the time they were able to arrange the vehicle, the doctors at SMK Civil Hospital declared Khitis Nath dead. PW2 further deposed that inquest proceeding was done there and thereafter, postmortem examination of the dead body of the disease was performed full stop. After postmortem examination, the dead body was handed over to them and full stop. Subsequently, last rites were performed, full stop. It was on the following day, the wife of the deceased, Mamoni Nath, within bracket PW1, lodged the FIR, post of PW2, stated that the police recorded his statement, post of Sampera. During cross-examination, PW2 stated that the deceased, Kitis Nath, was his cousin brother, within bracket son of his uncle. Post of PW2 disclosed that the bamboo bench where the disease sat prior to the incident was owned by Ranjit, the owner of a pan shop. As regards the place of occurrence, PW2 stated that there were total 4 shops at Nirola shop and a cycle repairing shop was owned by him. Full stop. Dhanjit was the owner of the pan shop and the accused owned a tea stall. Full stop. The other shop, which was a grocery shop, was owned by one Moloidas. Full stop. As regards the PW2 further stated that the incident took place at about 1/1:30 p.m. and at that time, he and Jiten Das were present. Full stop. Other persons arrived at the PO immediately after the incident. Full stop. PW2 stated that accused used to sell foolery, papur, etc. at his tea stall, and the deceased used to take tea at the tea stall of the accused. Full stop. PW2 stated that he also used to take tea sometimes from the tea stall of the accused on credit. Full stop. PW2 clarified that by the time they arranged the vehicle and money to take Kitisnath to the GMCH, the doctors declared him dead, and as such, they could not take him to the GMCH. Full stop. PW2 denied suggestions that he did not tell before police that the doctors at SMK Civil Hospital advised them to take the injured comma, Khetisnath to the GMCH, semicolon, that and that they arrange money and one vehicle to take Khetisnath to the GMCH as asked by doctor. But by the time they were able to arrange the vehicle, the doctors of SM a civil hospital declared Khetisnath dead. Post op. However, no part of PW2's police statements were marked by the defense. And thereafter, confronted the IO PW9 with such marked part of the PW2's police statement to bring any kind of contradiction on record. Full stop. PW2 also denied a suggestion that Khetisnath went to the tea stall of the accused and asked the accused to give him tea, fulori, papor on credit. Tea and other eatables, tea and other eatables on credit. And when the accused refused to give him, give those to him, Khetis pushed him and Khetis pushed and pulled the accused down on the ground and sat on the body of the deceased. And a knife which was in the hand of the accused then, pierced into the body of Khetisnath accidentally. Full stop. Para. PW4, Mr. Mahajan, you have any case?
Right.
You have to come after
Right.
break.
Right.
PW2, Zitendas. Stated that he knew the informant, the accused and the deceased, as all of them hailed from his village. Rostam. PW2 testified that the incident occurred 7 years ago. Rostam. On the incident, PW4 deposed to the effect that the accused inflicted a stab injury on Khetisnath by knife just above the abdomen, above his abdomen and just below his chest. Post op. PW4 further stated that on the date of the incident, just before, on that day, just before the incident, Khetisnath and he, PW4, were sitting on the bamboo bench near a shop of Kalisharan Nath, PW 2. Full stop. At that time, no, full stop. Oh, after thereafter, when Kittisnath wanting to go home, comma, uh, when near his motorcycle, the accused came near him and inflicted the stab injury on Kittisnath by a knife in his presence. Full stop. The Kittisnath shouted that the accused Nilo Kanto gave him a stab injury by a knife. Full stop. Then, comma, he, PW 4, and Kaliswaran Nath, PW 2, took Kittisnath to Kokoya Hospital. Full stop. But the doctor was at Kokoya Hospital referred the injured, comma, Kittisnath to SMK Civil Hospital. Full stop. Again at SMK Civil Hospital, comma, the doctors there referred Kittisnath to GMCH after stitching the injury. Full stop. But after 10 minutes, comma, Kittisnath succumbed to his injury at SMK Civil Hospital. So thereafter, comma, the dead body of Kittisnath was brought home after conducting postmortem examination. Full stop. Saptera. During his cross-examination, comma, PW4 stated that the deceased was his co-villager. Was his co-villager and their houses were close to each other. Suburi. What is it? Suburi? What is the English?
The same locality.
How so close to each other? Close up. On the incident, comma, PW4 further stated that he and the deceased were sitting on the bench when he and were sitting when the accused, comma, sorry, PW2 Kaliswaran Nath was present near them at that time as his cycle repairing shop was there. Full stop. The tea stall of the accused was at a distance of about 30 feet from the bamboo bench where he and the disease sat on that day. When Kshitishnath shouted that the accused Nilakanta inflicted him stab injury by a knife, he, PW4, was sitting on the bamboo beds with his head down. And the distance was about, and his distance was about 15 feet from the spot where Kshitishnath and the accused had an altercation. Had an altercation which was followed by the stabbing incident. Full stop. Like PW2, PW4 also stated that there were 4 shops at Nirola shop at the time of the incident. At the time, 4 shops at Nirola shop. And at the time of the incident, only the shops of the accused and Kaliswaran Nath PW2 were open. So the other 2 shops were closed at that time. PW4 further stated that he was sitting on the bamboo bench from a time prior to arrival of Kshitishnath. PW4 further stated that it was he, Kulendas, PW6, and Kaliswaran Nath, PW2, who took the injured, Kshitishnath to the hospital in a car. So, after the incident, several villagers came to the place of occurrence. So, PW4 denied the suggestion that the deceased had to pay credit amount to the accused Nilakanta. And he had deposed falsely. PW4 further stated that he saw a knife in the hand of the accused and It was he who separated the accused from the deceased. Full stop. He noticed the knife in his hand, in the hand of the accused at that time. But what happened to the knife thereafter was not known to him. Full stop. PW4 also denied the suggestion that as the deceased was closely was close to him, he had deposed falsely before the court. Full stop. Yes. PW6. Thomas Kulendas. Deposed that he knew the informant, the deceased, and the accused, as all of them hailed from his village. Full stop. Period 6 stated that the incident took place 7 years earlier. Full stop. Period 6 stated, having heard that the accused had stabbed the deceased, he came to the place of occurrence. Immediately thereafter, and on reaching the PO, he noticed that it is not sustained an injury on his abdomen, and there was profuse bleeding from that injury. Full stop. PW6 acknowledged the presence of the accused, Khitis Nath, Kaliswaran Nath, PW2, and Ziten Das, PW4, at the PO at that time. Full stop. PW6 further stated that injured Khitis Nath was immediately taken to Kokoya Hospital in a Maruti car after stopping it. At the place of occurrence, PO. So when the injured was first taken to the hospital at Kokoya and thereafter, to SMK Civil Hospital at Nalbari. Full stop. He accompanied the injured to the hospital. Full stop. It was after 10 minutes. It was 10 minutes, or after 10 minutes from the arrival at SMK Civil Hospital, Khitis Nath succumbed to his injury. So PW6 also stated that postmortem was done Postmortem examination was done on the dead body of the deceased at SMK Civil Hospital. After the postmortem examination, the dead body was taken home and the last rite was performed at village. Full stop. Don't think it will reach.
I'm for the item number 7.
Uh-huh.
My senior will not be able to come today because of the water logging.
Waterlogging,
Yes.
genuine issue. Okay.
Be on 22nd August, the case.
Don't fix a date. It will be listed. PW 6 was released. Yeah. In cross-examination, PW 6 stated that he did not witness the incident of stabbing. And he heard about the incident from Kalisharan Nath, PW 2, and Jiten Das, PW 4. When he reached the place of occurrence immediately after the incident. Post up. As regards the his relation with the deceased, PW 6 stated that deceased was not his relative and was only a co-villager. Full stop. He stated that he arrived at the place of occurrence at about 1:30-2 p.m. By the time, there was gathering of about 40 to 50 persons at the place of occurrence. And they were all from their village. From the village, were from both the accused and the deceased hailed. PW 6 stated that though both the accused and the deceased hail from one village, but their houses are at different Chupa, yes, CHUPA, Bishop in bracket 21 to asylum. Poster. PW 6 who did not witness the incident, denied a suggestion of the defense that during scuffle between the accused and the deceased, which ensued when the accused demanded payment owed by the accused, the deceased fell down and the knife present in the hands of the accused accidentally hit the deceased. Full stop. Para. The prosecution witnesses PW 7, Soneshwar Nath and PW 8, Ramesh Das are co-villagers. from their testimonies, comma, it has emerged that they did not witness the incident. Full stop. PW 8 stated that hearing the news that the accused stabbed the deceased, comma, he went to the hospital. To know about he went to the hospital and found that the disease was declared dead, already dead. Full stop. Para. PW1, comma, Mamoni Nach was the wife of the deceased and is the informant of the case. Full stop. PW1 stated that on the date of the incident, comma, her husband, who worked as a mason, comma, went to Bornibari Bazaar in the morning, and she heard later on that her husband was assaulted by the accused near his tea stall and the cycle repairing shop of Kalishwaran Nath PW2. At Pusta. At Malai. When she was informed about the incident and that her husband was taken to Kokoya Hospital and to the civil hospital at Nalbari. She went to Kokoya Hospital at first and then to Nalbari Civil Hospital. Thereafter, post of PW1 stated that at Nalbari Civil Hospital, she found the dead body of her husband. And thereafter, she lodged the FIR. Post of PW1 exhibited the FIR as EXT1, which was signature therein as EXT 11. Post of. It was after postmortem examination, comma, the dead body of her husband was handed over to them. Post of. After receipt of the dead body, comma, the same was cremation was done. Post of. PW1 further deposed that after the search, comma, the accused, in order to avoid the trial, changed his place of abode and was staying in a temple as a priest. Post of. During cross-examination, comma, PW1 stated that the place of occurrence was at a place of occurrence, that is, Nirola Chowk, was at a distance of about 1 mile from her house. PW1 denied a suggestion that There is a suggestion given to her by the defense that her husband went to the tea stall of the accused and asked the accused to give him tea and other eatables on credit. And when the accused refused to give her husband, refused to give tea and other eatables to her husband on credit, her husband pushed the accused, pushed and pulled down the accused on ground. Closed up. She also denied the suggestion that when her husband was sitting on the person of the accused, the knife which was in the hand of the accused pierced into the body of her husband accidentally. And her husband died due to his own fault. PW9, Hirok Nuts was the son of the deceased. In his testimony, PW9 deposed to the effect that on the date of the incident, he was present in his house on the time and date of the incident. At the time and on the date of the incident, he was in his house. He was informed that after the stabbing, by the accused, his father was taken to the civil hospital in Nalbari by Kaliswaran Nath, PW2, Jiten Nath Das, PW4, and Kulen Das, PW6. When he reached the civil hospital, Nalbari, he came to learn that his father succumbed to the injury. After arrival of the police personnel at the hospital, inquest on the dead body was done at the civil hospital Nalbari in his presence, and thereafter, post-mortem examination was performed on the dead body of the deceased. PW69 exhibited the inquest report as EXT3 with his signature therein as EXT31. Full stop. Software. During cross-examination, PW69 stated that the place of occurrence was at a distance of 1 kilometer from their house. Full stop. When he went to the PO, that is Nirola Chowk, he found gathering of person there. Full stop. A similar suggestion has given to his mother, PW1, was given to PW9, and PW9 denied the suggestion first. Fair. From on appreciation of the testimonies of the above prosecution witnesses, comma, we find that the prosecution has been able to establish that the place of occurrence was in the vicinity, was near stroke in front of the was at Nirola Chowk or village Kokoya. Full stop. In and around the place of occurrence, comma, there were 4 shops. Full stop. One of them, none of the shops belonged to the accused, and another belonged to Kaliswaran Nath, PW2. Post of the prosecution has, it has been established that the incident had occurred at around 1:30 p.m. on 10/7/2012. Full stop. At that time, comma, only the shops of Kaliswaran Nath, PW2, and the accused were open, and the other 2 shops at Nirola Chowk were not not open, were closed. Full stop. One of the considerations before appreciation of the eyewitness accounts is ascertainment of the presence of the eyewitnesses. A eyewitness, an eyewitness at the place of occurrence. One of the considerations before testing and before analyzing the veracity or otherwise of an eyewitness is to find out whether the presence of the eyewitness at the place of occurrence is believable or not. Full stop. The prosecution has been able to establish that it has been established from the evidence on record that Kaliswaran Nath PW2 had a shop at the PO, near the PO. Full stop. The presence of Ziten Das, PW4 at the PO from a time anterior to the incident was not denied in any manner by the defense. Full stop. It is one of the objects behind the examination of the accused under section 313 CRPC is to enable the accused to explain any circumstances appearing in the evidence against him full stop. Though the explanation given, though the statement of the accused given under section 313 CRPC is neither a substantive nor a substitute piece of evidence, but such statement can be used to examine the veracity of the prosecution case. It is tried that such a statement, is not on oath, does not qualify as a piece of evidence. However, the inculpatory aspect, as may be borne out from the statement, may be used to lend credence to the case of the prosecution. Full stop. When the accused was examined under section 313 CRPC, he in clear terms stated that his shop and the shop of Kalishwaran at PW2 were near the PO. full stop. The accused had admitted that Kaleshwaranath PW2 had a cycle repairing shop there, whereas he used to run a tea stall. Full stop. In answer, in reply to the query, what the testimony of PW2 that on the date at the time and on the date of the incident, the deceased sat on the bamboo bench with Ziten Das PW4 at the PO. The accused without denying and he came with a knife and stabbed the deceased. When the deceased was about to go home on his bike, the accused, without denying, the accused had provided an explanation by stating that the deceased came to his shop and asked him for mixture. And when he refused to give them mixture, he was assaulted by them on his head and shoulder. Full stop. From the when the evidence on record and the explanation provided by the accused during his examination under Section 313 CRPC, it has clearly emerged that the accused had not denied the presence, I had admitted the presence of the prosecution witnesses Kaleshwaranath PW2 and Ziten Das PW4 at the PO at the time and on the date of the incident, apart from the deceased. Full stop. Thus, the presence of the two prosecution witnesses, PW4 and PW2 and PW4, whom the prosecution claimed as eyewitnesses to the incident of assault on the deceased by the accused, has been proved. Full stop. Has been established beyond doubt. Full stop. The prosecution witnesses, PW2 and PW4 were equivocal in their testimony to the effect that the accused had inflicted a stab injury on the person of the deceased below below the
Yes, above abdomen.
below the below the abdomen,
Chest.
below the
chest,
chest and above the abdomen. Full stop. In order to find out the veracity of that part of the testimonies of PW2 and PW4, we now turn to the medical evidence, which are in the forms of testimony of the autopsy doctor, PW5 and a PME report, EXT2. Full stop. PW5, Dr. Prabodh Kumar Sharma was, on 10/7/2012, serving as the Deputy Superintendent at the Civil Hospital, Nalbari. Full stop. In his evidence in chief, PW5 testified that on that day, that is, on 10/7/2012, he performed postmortem examination on the dead body of the deceased, Kshitij Nath, a male of 35 years of age, in reference to Belsaur Police Station, General Diary Entry number 177, dated 10/7/2012, and on being identified by UBC, Dipen Das of Belsaur Police Station and Ramesh Das. Within bracket, PW8, a relative of the deceased. Full stop. PW5 deposed to the effect that after autopsy, he found the following: page 17, A2, A. In his opinion, PW5 opined that the death of the disease was caused by massive intra-abdominal hemorrhage due to injury to liver, spleen, and large gut. Full stop. The injuries were found to be antemortem in nature. Full stop. PW5 exhibited the postmortem PME report as EXT2 and his signature. Therein as EXT21, full stop. He further stated that the PME report EXT2 was countersigned by the Joint Director, Nalbari, full stop. When PW5 was cross-examined by defense, He stated that the dead body arrived at the morgue at 4:30 p.m. on 10/7/2012, and the autopsy was conducted at 5 p.m. on the same date. Full stop. In the PME report, EXT 2, the following findings were recorded. Is 53. Like a star study abdomen. Fifty-three, 54, 55. Prior to the postmortem examination, inquest proceedings on the dead body of the deceased was conducted at 4:30 p.m. on 10/7/2012, and as per the inquest report EXC3, conducted by the executive magistrate, major injury was present in the left upper side of the stomach. Full stop. When the medical evidence, mentioned above, are considered vis-a-vis the eyewitness, the ocular testimony of the two eyewitnesses, PW2 and PW4, we find that the ocular testimony of the two eyewitnesses received corroboration from the medical evidence that the disease sustained a penetrating wound over late hypochondrium and of size 3 centimeter into 1 centimeter, and the injury had sharp inverted margins directing in medial direction. Full stop. As a result of the injury, the stomach, the peritoneum was ruptured, and the abdomen contained blood. Full stop. The stomach and large intestine and the spleen was ruptured as a result of the injury. Full stop. The issue which does arise for consideration is whether the date of the deceased would come within would Yeah, was date of the disease was, sorry, the date of the disease, sorry, the accused, oh, sorry, deceased met his death as a result of an act of murder, comma, as contended by the learned public prosecutor, comma, or uh, the death of the accused was culpable homicide of the second degree, comma, as contended by the learned amicus curiae. Full stop. Having regard to the nature of injury, sustained by the deceased, the part of the body where the injury was inflicted, and the alleged weapon of assault which was used to inflict the injury, and the proximity of time and the duration of time within which the accused make the accused succumb to the injury. It has emerged privacy that the act the death of the deceased was a homicidal death. Full stop. IPC con screen. A 299. If Farooq Ahmed, friend of Farooq Ahmed, para 28. Huh? Para 28. 299 or section 300. Huh? At the cost of repetition, comma, we find we have of the from the evidence stroke materials on record, comma, it is found that the disease sustained a bodily injury, and such bodily injury was caused in the vital part of the body, comma, that is medical term key area to medical term Uh, vital part of the body, that is, medical, hypochondrium. Over the hypochondria. A medical evidence. So the medical evidence has established that it was a penetrative wound over the hypocardium, which ultimately led to the established that it was the penetrative wound over the hypochondrium, resulting in massive intra-abdominal hemorrhage due to injury to liver, spleen, and large intestine, sustained by the deceased, had ultimately led to his death. Full stop. From the evidence of the prosecution witnesses, it is also established that such bodily injury was caused by the specific act on the part of the accused. Full stop. Thus, and such bodily injury was inflicted by the accused by a knife, iron knife. Full stop. Though the said iron knife was not recovered by the IO during the investigation. Full stop. Notwithstanding non-recovery of the alleged weapon of assault, we would advert to the factum of non-recovery of the alleged weapon of assault in the later part of the order. Full stop. We, from the above evidence, we have no hesitation to hold that it is a case of culpable homicide. Full stop. It was such bodily injury such a bodily injury which was sufficient in the ordinary course of nature to cause death. Full stop. Para. The issue which is arising now is whether the offense falls in the category of culpable homicide amounting to murder or culpable homicide not amounting to murder. Full stop. Para 29. Farooq. itu position নেই কিন্তু সব কিন্তু position হয় রায়া ভালো ইন্টারেস্টিং একটু করে হবে একটু নাসিম আক্তার হ্যাঁ নাসিম আক্তার প্যারা 24 রায়া ভারাপু পুনাইয়া প্যারা 25 24 25 26 তাৰপিছত বেলেগ প্যারা from the definition of definitions of culpable homicide as defined in from the definitions of culpable homicide and murder, as defined in section 299 IPC and section 300 IPC, and exposition on the said two definitions by Birsa Singh Supra and Raya Bharapu Punaiya Supra. Comma from the definition of so it has been exposited by Birsa Singh Supra and Raya Bharapu Supra that even if the intention of the accused was limited to the infliction of a bodily injury sufficient to cause death in the ordinary course of nature and did not extend to the intention of causing death, the offense would be murder, quote unquote. Postum. The Honorable Supreme Court in Raya Bharapu, Punaya, has referred to Tira Section C, Appended to Section 300 IPC, and has held that the said illustration has clearly brought out the point. First of para Farooq. Farooq Mahai, Nasim Akhtar, para 29. Dhiraj Bhai, right? Dhiraj Bhai. You have referred to Dhiraj Bhai?
No, I intend to my lord place mail.
Huh?
One Sandhya Yadav, I did not place anything.
Okay. Para 29. Whether the case would come within the exception of 4 or not. Huh? Para 29. reverting back to the facts of the case in hand. Non-recovery to লিখি ল'ব লাগিব ন? Non-recovery to লিখি ল'ব লাগিব। Non-recovery to লিখি ল'ব লাগিব। মানে দিগদাৰি হ'ব। এই non-recovery to আছিল কথা। হেডিং এটা আছিল non-recovery। এইটো। The learned amicus curiae has pointed out that the IO, though the case of the prosecution was to the effect that the injury was inflicted by the accused by a knife, there was no recovery of the iron knife during the course of investigation. Full stop. We have already found that from the above discussion, that there is no reason to disbelieve and doubt the credibility of the two eyewitnesses, PW2 and PW4. The law is well settled that there can be a conviction on the basis of deposition of even a sole eyewitness, if the said witness is found to be trustworthy and reliable and credible. Full stop. Law is also settled that recovery of the weapon used in the commission of the offense is not a sine qua non to convict the accused. Full stop. If there is a direct evidence in the form of eyewitness, even in the absence of recovery of weapon, the accused can be convicted. Full stop. Within bracket, REF, State through Inspector of Police versus Lali, alias Monikandon, and another, etc. 2022 15 SCR 613. আৰু কেইটামান আছে। Lali, LY. On further scrutiny of the testimonies of the two eyewitnesses, PW2 and PW4, it has emerged that at the exact time when the assault was made by the accused, Man wrote these things. The PW 4 was at a distance of about 15 feet. PW 4 was sitting on the battlements, was at a distance of about 15 feet from the accused and the deceased. Full stop. Kalison at PW 4. Did not mention in clear terms as from where he witnessed the act of assault on the deceased. Full stop. PW 4 had a cycle repairing shop in the near the spot where the disease was tamed. Full stop. PW 4 did not mention about any altercation between altercation between the accused and the deceased. Full stop. PW 4, PW 2, PW 2. It was PW 2 who deposed that when he was sitting on the bamboo bench, the deceased at a distance of 15 feet. No, the accused and the deceased entered into an altercation at a distance of 15 feet from him. And such altercation was anterior to the act of stabbing by the deceased on the by the accused on the deceased. Full stop. Admittedly, comma. No, admittedly, it is, we find that it is also established that the accused had a tea stall near the spot where he stabbed the deceased. Full stop. Having a tea stall near the spot, comma, uh, it is not unusual, not unusual. It is not unusual. Huh? নহয় নহয় চুৰিখন where he is to prepare কি আছিল কি চব্জি নে কিবা আছিল নেকি? হা পকোৰা পকোৰা where he is to prepare pokora eatables where is to prepare eatables. It is not unusual for the accused to have an iron knife at his hand. Full stop. As the disease accused used to run the tea stall at near the PO, comma, his presence at the PO is also not unusual, was also not unusual. Full stop. As a corollary, comma, and during 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 at that time of the day was not unusual. So it was the diseased who on his way to his house made a halt at the PO. Meaning thereby, comma, there was no full stop. And the same goes to show that the accused there was no premeditation. So the incident of assault was not with premeditation. Full stop. It has emerged from the evidence on record that there was any prior animosity between the accused and the deceased. Full stop. তার আগর line to. Other than the IO and the autopsy doctor, all the other prosecution witnesses were villagers, were co-villagers of the accused and the deceased. And none of them had deposed to the effect that there was any prior animosity between the accused and the deceased. To stop. Had there been any prior animosity or the disease accused was adversely disposed towards the accused was adversely disposed towards the deceased, the wife of the deceased and the son of the deceased, that is, PW1 and PW9, would have been the best, were best positioned to depose on the said aspect. Full stop. Thus, it has not emerged that there was any prior animosity between the accused and the deceased. There was any animosity, prior to the incident. Full stop. It is in such situation, it is it is no? Mm. The incident, the act of assault, it is not, sorry, it is not the discard, it is not it cannot be discarded outrightly. As contended by the learned amicus curiae, that the act of assault might have happened during the course of such quarrel and altercation between the accused and the deceased and the accused who had an iron knife in his hand. Inflicted the stab injury on the person or disease, albeit albeit on a vital part in the heat of passion. Full stop. Explanation to exception 4. Although there was no overt act on the part of the deceased, explanation to exception 4. Of section 300 IPC. Has provided that it is immaterial in such cases which party offers the provocation or commits the first assault. Full stop. It is also well settled that when from hypothesis, yes, from two hypotheses, two hypotheses, that which went from a from the evidence on record to two possible situation emerge, the situation which is to the benefit of the accused, the situation which is a situation. Two views are possible, there's the theory, there's my report to Ahane. Report to Ahane. There's this. In view of the principle, in view of the fundamental principle of criminal jurisprudence, that benefits benefit of doubt, at all stages, goes in favor of the accused. After inflicting the after stabbing the after giving the blow with the knife, the accused did not give any further blow on the deceased. An injury inflicted as the injury inflicted was on the vital part of the body, it cannot be presumed that the accused did not have the knowledge that the bodily injury inflicted by him by the knife was not sufficient in the ordinary course, ordinary nature in the was not sufficient in the ordinary course of nature to cause death of the deceased. Post of para. From the above discussion made and the reasons assigned herein, we are of the considered view that the case is one which comes within the scope and ambit of exception 4 of section 300, IPC. Full stop. As the accused had caused such bodily injury, which led to almost instantaneous death of the deceased, and such death was caused by the accused without premeditation in a sudden quarrel and fight. In a sudden fight, in the heat of passion, upon a sudden quarrel, and without the accused having taken undue advantage or acting in a cruel and unusual manner, he is guilty of the offense of culpable homicide, not amounting to murder under first part of section 304, IPC. Thus, the conviction of the accused under section 302, IPC is not found sustainable in law. We therefore hold that the accused appellant is guilty for the offense under the first part of section 304, IPC. The conviction of the accused appellant under section 302, IPC is therefore set aside. Para. It has been contended by the learned public prosecutor for the state that amicus query that the accused appellant is about 60, 70 years,
Now, as per
was
224
about 60 years of age at the time of the incident, and is presently about 70 years of age. So on the other hand, Mr. The other additional public prosecutor appearing for the state has submitted that immediately after the incident, the accused could not be arrested as he was hiding from in a house of his relative, as admitted by him in his examination under section 313 CRPC. Full stop. The materials on record has further established that after after submission of the search sheet and commitment of the case to the Court of Sessions, the accused did not appear before the learned trial court, and for a period of 4 years, he, by changing his name, avoided to face the trial by purportedly by disguising himself as a priest in Kamakhya temple for a period of 4 years. And as such, no leniency should be shown to him, considering the fact that the deceased died at the age of about 35 years, leaving behind কিবা compensation দিছিল নহয়?
Please.
Leaving behind
Wife, children and parents.
his wife,
Para 49, page 49.
leaving behind 30.
Five children, parents. Page 49.
এইটো 9 to কিমান বছৰ? 9 to 20 years. 20
Right.
years মানে 14 বছৰ আছিল তেতিয়া। 2020 ঘটনাটো কি হৈছে? 14 বছৰ আছে, মাইনৰ আছিল তাৰমানে।
Right.
Leaving behind his wife and minor children at that point of time. Post up. In response, Learned amicus curiae has submitted that the accused had no criminal antecedent other than the crime, other than the one in hand. Full stop. Having held the accused guilty of the offense under the first part of section 304 IPC and taking into account the obtaining facts and circumstances in its entirety, including the facts that at the time of committing the offense, the accused had no prior criminal antecedent, and at present, he is about 70 years of age. We are of the considered view that A sentence of 8 years of rigorous imprisonment will subserve the ends of justice. So there is, however, no alteration as regards the amount of fine to be paid by the accused. And the order as regards fine, as passed by the learned trial court, is maintained. Therefore, the sentence of the accused appellant stands altered from imprisonment, rigorous imprisonment for life to rigorous imprisonment for 8 years. Full stop. We also affirm the direction given by the learned trial court as regards disbursement of the fine amount in a manner indicated, if the fine amount is realized. Full stop. We also reiterate the direction given by the learned trial court to the District Legal Service Authority Nalbari for determination of the quantum of compensation to be payable to the next of kin of the deceased. In terms of the provisions contained in section 357A CRPC and the extant victim compensation scheme, framed there under. Para. Before parting with the record, we wish to place our appreciation on record as regards the services rendered by Mr. N.J. Das, learned amicus curiae appearing for the accused appellant, and direct the registry to make available to him just remuneration as per the notified fee structure available to the amicus curiae. Most of the records of the direct court are to be sent back forthwith. কিবা আপুনি সোমাব? Oh. Started কৰিব পাৰি। Single
Item number 1.
How many witnesses?
12, my lord.
12.
Yeah, my lord. My lord, here are the two, my lord. For acquittal also, my lord, possibly limited materials, my lord. But my lord, as because no serviceman amongst the appellants, my lord. No service holder, my lord. Amongst the appellants, my lord. And already they are there for 5 years, my lord. So, my lord, to summarize, my lord, as a student of law, my lord, with all respect, my lord, it cannot be because no weapon was carried, my lord. It was mutual market, cross case was there, my lord. And thereafter, my lord, with all respect, my lord, no predetermined mind, my lord, with all respect, my lord, no weapons were carried. Only 3 branches of trees, my lord. That too, after examination, my lord, no blood stain. And 7 accused appellants, my lord. And only 1 single injury, my lord.
Now, how many accused here?
7 appellants, my lord.
7.
I'm sorry, 10 appellants, my lord. 10 appellants, my lord.
It would require some time, means to find
My
out.
lord, if your lordship What I do understand, I may be wrong, my lord, upon to modification, my lord, as your lordship suggests, my lord. So if, my lord, with all respect, my lord, if conversion, if I pay for it, my lord, that the entire evidence, my lord, because we did not carry any arm, if those parts are read out, my lord, possibly it would fulfill, my lord, with all respect. And already they are there for more than 5 years, my lord, with all respect, and single injury, my lord.
Right, but
Oh.
to come to a view, it would take some
Yes,
time.
yes, my lord, yes,
Ultimately, it has to be
absolutely, my lord.
brought down in black and white.
Yes. I have understood, my lord. I have understood. Should I
It
begin?
needs some effort.
Yes, ma'am. I have understood. Should I be-
No, today is not possible. Fix করে দিও।
Can it be tomorrow, my lord, with all respect? We have done our homework, my lord.
Fixed. খালি আছে। রাজদিকে ফিক্স করিল। নেক্সট মানডে ফিক্স করেছো নাকি? Oh, we have also a routine in mind.
My lord, as your lordship pleases.
We have fixed also few
My-
matters.
my-
Huh? After it is DBS. Next Tuesday, practice. We don't know whether we'll be sitting or not, but
Right.
we can fix it on next Tuesday.
Can it be, should I, they have asked me, my lord, can it be part heard, my lord? Can it?
No, I'm not heard it.
Yeah, you have not heard.
I am not opened it.
Yes, ma'am, yes.
I have only seen that on the request of Mr. B.K. Mahajan.
My,
Learned counsel for the appeal and list the appeal after.
Yeah,
it.
Major
I have seen this much only.
I am happy, my lord.
Because it is not short. I just
but-
had a glance at the volume of the paper book and just the length of few of the testimony of few of the eyewitnesses. It appears to be long.
Oh.
No,
No.
some
Yeah,
the length of few of the eyewitnesses is
My-
long.
my lord, my
So
lord.
at this time, it is very difficult to.
Yes.
Thursday, next Tuesday. Thursday, we have a division. So the Belagata division match. Okay. As agreed, as sought for by Mr. B.K. Mahajan, Learned Counsel for the Appellants, and M.S. A. Begum, Learned Additional Public Prosecutor for the Respondent State of Assam, release the appeal on Tuesday.
13.
My lord,
13
my lord.
years.
How many years?
We are there for 5 years, my lord.
5 years.
5 years. Obliged.
DPS.
Item numbers 2 to 4.
Long. DPS.
May it please your lordship. Lordship, appeal against conviction.
4 appeals.
3 appeals in total, 4 accused persons.
NDPS.
Yes, lordship.
At this time, it is not possible to conclude any small appeal.
5 years, 3 months already.
No, I am not saying that. This is NCB and NDPS.
Lordship.
It is not it will not be possible to conclude, right? Within 1 hour. Paper book, paper book. There is something amiss in paper book, right? It is now complete.
It is completed, lordship. We verified it.
Some complaint was sent.
Now fresh paperwork was issued.
Huh?
Now fresh paperwork has been given to us.
Done it. এখন কি এটা কি দুখন কেনেকে আহিছে দুখন কি কি আছে প্রবীণ কুমার NCP EXT
That two paper book.
Yeah, here, one is old and one is corrected one.
Which one is big one is corrected one?
It's a, I think it's a red mark,
This one?
this one.
Huh?
Let me check once, my lord.
Running into 300 pages, 304 pages.
Yes, my lord,
Huh? This is the new one.
yes.
It wrong. I made it. MS Nargis, it will not be possible to be fair enough. Possible today. If we start also.
In this case, only, about there, about 8 years.
It is not a case of yes or no. We have to decide.
Yes, yes, also.
If it is a multiple choice question, I could have ticked it.
Only issue involved in this case, lordship, like earlier case, lordship, only 50.
Can it be possible in 2
No.
pages? No. And it is difficult. How many witnesses?
6 witnesses. 6 witnesses, lordship. Six witnesses, among them only PW3 is the seizing officer and PW5 is investigating officer. They are the relevant witnesses.
MS Nargis is not possible today.
Lordship,
Someday else,
lordship,
after a week.
lordship,
We'll not go on fixing, but we'll take up as and when next time comes.
lordship.
If it is during the first part of the day, it would have been better.
Yes, lordship. It's a very voluminous record that is there.
We have to see ultimately all the records.
Yes, of course, lordship.
Ultimately, the conclusion may be yes or no. But the thing is that
With a fresh mind,
due to
lordship.
paucity of time.
Morning hours.
Hard Miss and SK Nargis. No, I don't give such kind of order. I never give top of the list.
No, lordship.
I don't give.
No.
This is not a convention of
Yes, yes.
this court. SK Nargis for the appellant, SC Kyle for the respondent NCB are present due to paucity of time, the appeals could not be taken up today. List the appeals after week on a date to be fixed by the court. As and when it comes up on the top, we'll take up.
Lordship.
At
Obviously,
3:30, it will be very difficult.
with a fresh mind, lordship. That will be better for us.
Let us
Item
be
five.
practical also.
Lordship.
Item 5,
Obliged, lordship.
How many witnesses?
My lord.
28 not
28,
possible.
And he is in jail for last 8 years, 6 months. maybe.
No, mister.
Only a date maybe I'm praying for trial.
Same thing, we will. And 28 is not possible at 3:45.
Malad, out of 28, Malad, there
One.
is
Now, what is the principle for deciding a criminal appeal? By the appellate court.
no what I'm
Just
saying.
pick up one witness and decide the appeal.
No, I'm not.
Is it a law?
I'm only
No,
asking for a
we have
date.
to go through all the
Yes.
28.
Yes,
Just because the counsel for the appellant is saying that only one is vital,
no,
then what all the decisions of the Supreme Court, Mr. Counsel?
no, I'm not saying that, my
Right.
lord.
Paucity. B. Borwa. You are
Yes,
counsel for the appellant, single,
yes.
and B. Huh? Paucity. After we can date to expire office.
Can you have a date, my lord?
It is submitted 1 minute or it is there 8 years. It will come accordingly.
item 6,
Obliged.
They calculate and they list. Short, it is 7 to the water logging.
6.
6.
May it please your lordship. Lordship, this is a appeal against conviction, lordship. POCSO, my lord.
So, how many?
We have 9 witnesses, lordship.
Age?
70 at the time of giving judgment, lordship. At present, around. 70.
Judgment is not required at the time of incident.
At the time of incident, lordship, 65, around 65, because judgment was passed in the year
Huh?
2019.
No, the victim.
Victim.
We are not considering the age of the disease.
Sorry,
Oh, sorry, appellant.
Apology, lordship. 9 years, 9 years.
9 years.
9 years.